All right, everybody. Thank you guys for coming, spending some time with us this afternoon. Most of you that are on the call are already familiar with Stewardship, but for those that aren't, Stewardship Technology is an all-in-one donation management platform with kind of a singular purpose. It's our mission to help you fund your mission. So whether you're a brand new nonprofit or an established one, Stewardship has products and support, coaching, a system that can help you increase donations so you can better fund your mission. Joining us on the webinar today are some new partners of Stewardship's Charitable Allies. Joining us are Zac and Olivia from Charitable Allies, and we're so excited to introduce them to our existing client base and future clients. Charitable Allies, what they do is they help guide nonprofit leaders through legal challenges so they can run thriving nonprofits that hopefully can change their world with their mission. They provide comprehensive legal services and education at a pretty low rate and can assist with any type of legal needs such as nonprofit startup paperwork, contracts, mergers, dissolution, to any type of litigation. Joining us today as our featured speaker is Zac Kester. Zac is the CEO and managing attorney at Charitable Allies. He's got a decade of experience helping nonprofits legal challenges, all shapes and sizes, litigation to mergers to basic compliance questions. He's got his JD from Indiana University, certificate in fundraising management from Indiana University as well, and won the 2018 Leadership in Law Award from the Indiana Lawyer. As kind of a reminder for everybody, we'll take questions through the chat functionality at the bottom of your screen. There'll be time for questions after the webinar. So if you have any questions about anything that you hear here, go ahead and submit that question through the chat functionality, and we'll get to it at the end of the presentation. So without any further ado, Zac, it's all yours, buddy.
Thank you so much for the time. Thanks for inviting me, Trey, to speak and be here and support you as you support nonprofits fund their mission. To your point, that's exactly what we do at Charitable Allies. In some ways, we don't run fundraising software, of course. We are attorneys for nonprofits, but perhaps more importantly, we are a nonprofit ourselves. So Charitable Allies is a legal aid law firm. We're a nonprofit. So not only do we advise nothing but nonprofits and their stakeholders, we live it. We are a nonprofit ourselves. And today we'll be talking about sort of the risk roadmap and what it means to have board members who are attorneys, and what interesting risks that actually drives for your organization. So about some of the differences between a family practice doc versus sort of a neurosurgeon, right? And we'll talk about that in the legal subject matters of attorneys and what they might know or not know, and what they may not even realize they don't know, right? And if the more of that you have at your fingertips, so to speak, then you'd be able to spot those issues as well as your board attorney. Then we'll talk about the importance of an attorney and their familiarity with regulatory investigations. One of them happens to your organization. And then lastly, insurance coverage issues. This one's actually rubber meets the road the most, and it's the most surprising of the three key issues in the ways that want to mitigate risk. So I broke one of the cardinal rules in having all these words on the slide. I'm actually not going to go through all of them, but what it does is it shows you that there are a lot of areas, what we might call specialty areas, focused areas, technical areas of the law that I have seen numerous attorneys who aren't focused on representing nonprofit organizations that they miss a lot. And it's just issues that they don't even know exist. To give you one example, there are actually 5 conflict of interest doctrines that apply to nonprofits. 5. 1 is a state law doctrine. 4 are federal tax law doctrines. And 2 of those 4 are almost entirely case law, so judicially created. And are not in the statutes or regulations. So there are several tests that go along with that. In fact, it's so complicated that I have a whole 1-sheet slide that's 5 rows and about 8 columns that I can use to analyze a specific situation for a client in terms of whether there's a conflict, and then lots of prompts as to what what the test is that applies. Similarly, UPMIFA, second bullet there, the Uniform Prudent Management of Institutional Funds Act. That's why we don't say that. It's ridiculous. We say UPMIFA. It's actually the law in all 50 states plus DC. It's been adopted in 49 of the 50 states as a matter of statutory law. And the law was created in Pennsylvania by the Pennsylvania Supreme Court, and then a body of high-end professors, if you will, called the Uniform Law Commissioners passed it as a uniform law, and then it's been adopted by all 49 states other than Pennsylvania, which had already adopted it via case law. It's called the most successful uniform legislation in history. But what's interesting is many attorneys don't realize it exists. And one key, very, very key issue that constantly gets missed is UPMIFA. It governs donor intent and donations, and when we can modify from donor intent, and what the standard is that we to utilize as charities when we invest our funds, and it covers a few other topics as well. But UPMIFA defines contract. It defines a contract relating to a donation, and the word it uses is gift instrument. Gift instrument. And a gift instrument is any writing wherever located that shows the understanding of the parties as to the gift. And it specifically includes the solicitation for when that gift or donation was given. And so what attorneys will commonly do is, okay, there was a large donation that came in. They'll say, oh, okay, well, I need to look at the will, or I need to look at the gift or the donor agreement, the contract, the written signed contract. And they think, okay, I've reviewed the entirety of the gift instrument. Most of the time they're completely wrong, because gift instrument is actually defined as any writing wherever located that evinces the understanding of the parties. So they have to look at email correspondence and letters. They have to look at the minutes of the board, if it was a large enough gift that the board of the nonprofit accepted the gift, et cetera, et cetera. There are various other places to look for what constitutes the actual gift instrument. So what is the contract? And what's fascinating, right, to me, because I'm a nerdy and I'm an attorney, is the other attorneys generally think, well, that's just kind of ridiculous. That's, that creates some uncertainty. We don't really know what the contract is. The law is very clear in our state. We look at the one document, and it's the four corners and only the four corners. And they're probably correct. In fact, they're almost certainly correct that might be the law. That may very well be the law in that case, in that state, in terms of generally it's the individual writing, it's the individual document that we called the contract and we signed, and that is the instrument. And they're correct in the default case. But UPMIFA actually is a specific statutory provision that modifies that default. And almost all attorneys, almost all of them, miss this issue. And in fact, if they are like corporate attorneys, they're corporate litigation attorneys, and they actually litigate contract law sometimes, business disputes, contract disputes, they tend to be the ones who get it the most wrong, because they just simply forget, or maybe don't even know of the existence of UPMIFA as a law in and of itself. And so this is an issue that they miss a lot. So they may be on the board, they love the mission of the organization, they love saving turtles, which I use that example because we have these little turtles all over my office, and I love sea turtles. So that's a great example for me. But it could be, of course, anything. They like working with children with disabilities, or re-entering society from a term of imprisonment, or whatever it is. They're pursuing their charitable mission, and they love the mission of the organization, and they've agreed to be on the board or help the organization on a volunteer basis. But sometimes helping can hurt if they're giving fundamentally wrong advice. And they're like, oh yeah, that's how we would interpret that one piece of paper associated with that gift, when in fact we look at all 6 pieces of paper together. That's one that gets missed a lot. So I'm not going to a lot of the rest are on this slide, but I think this is worth talking about. You just don't know what you don't know. It's that neurosurgeon versus family practice doc. Family practice docs are generalists. They do great work. I like my family practice doc a lot. That's the primary doctor, that we use. Me and my kids use. But the reality is if I had a need for brain surgery, I would not want my family practice doc doing brain surgery. The problem is most attorneys don't even realize that nonprofit is sort of brain surgery. It's highly, highly technical. It's highly regulated. There are only some parallels that we can from other areas of law. And in other ways, it's entirely unique. So it's a matter of knowing where the twists are at the right time. It's not to say it's not impossible to learn. That's a lot of negatives there. It is possible to learn, but sometimes it takes a lot more effort than attorneys realize. So one way we actually help attorneys that are on the board is that we'll just answer their questions. We'll spend 15 minutes. We'll give them a citation to a few statutes or regulations that would specifically apply. We'll sometimes have a one-page or a two-page sort of guidance document that we can provide to them while they're advising the organization. That's one way that we leverage volunteer attorneys to be more effective at their work with the organization. Another area where there's some risk with using your volunteer attorney who might be on the board or is just a volunteer is in the context of regulatory investigations. This is a body of law that we actually call administrative law in the context of like law school, right? If a lawyer learned an area of law, that would have been administrative law, this type of thing. And administrative investigations are unique. Regulatory bodies, when they're engaging in an investigatory function, actually have a lot more rights than are normal in the standard lawsuit context. So two entities or two people sue each other. Maybe there's a breach of contract or car accident or something like that. That's civil litigation. And those parties are generally on an equal playing field, and there are rules about how one party gets evidence and documents from the other, vice versa. And there's a process for that. We call that the discovery process. In the context of a regulatory investigation, the attorney general or the regulator has an awful lot more authority than the party that is being investigated. So I'm going to pause here and go to the other end of the spectrum, which is criminal law, where we have reason to believe that crime, reasonable probable cause that a crime was committed. Then a judge can issue a warrant, a search warrant, and then the police with that search warrant can go into a car or a phone or a house or something and investigate. And all along the way, the defendant or the at that point the suspect may not even know that some of that took place. So that's that other extreme. So, and then there's national security, which is on top of that. It's a whole nother world. So there's the civil litigation where the parties are on roughly on par. Then there's the other end of the spectrum of the criminal investigations. But then in the middle is this regulatory investigation world. And it's a fairly small percentage of the amount of law that gets practiced. So it's we find that there are many attorneys who they might try to utilize the strategies with or against the attorney general that they would normally utilize in a civil litigation context. And that often doesn't work well because the attorney general has a lot of authority. When the attorney general issues civil investigative demands, they have significant enforcement abilities of those civil investigative demands. It's not like an opposing party just asks some questions of you. There's some significant sort of authority that they have. So that means just standard litigation tactics don't go over well and simply don't work well with attorney generals and when they're doing investigations. Mind you, this is not just attorney general's investigation. It could be a Department of Ed investigation. It could be a Department of Health and Human Services investigation. There are any number of departments that would investigate nonprofits from time to time, and we've represented many organizations in the midst of such a regulatory investigation. But I'm using the attorney general investigation as the default here because that is the body in most states that has the authority and responsibility to oversee the charitable sector. An attorney who knows deeply nonprofit law is going to know the appropriate course of action. In fact, most commonly, the appropriate course of action is quickly fix whatever problem that might have existed, and then make a presentation to the Attorney General's office within a reasonable period of time, usually 30 to 60 days, of compliance. Let them know, oh no, this actually worked correctly. I'll give you an example. So we were representing a client in the midst of an Attorney General investigation, and this was out on in the Mountain West, one of the Mountain West states. And the Attorney General had received a complaint, and it was a multi-site organization. And one of the individual sites had sort of some staff and an advisory board, if you will, that wanted to sort of leave the company, if you will, which had the nonprofit, which had multiple sites. And so one of the sites just wanted to up and leave. And they have the right to leave. That's we have a First Amendment constitutional right to associate with each other. And so there's a right for them to leave. But there might have been some non-solicitation or non-competition agreements in place. There also might have been some specific grant funding contracts in place. And there might have been leases, such as a photocopy machine lease or a lease on some physical space, like a landlord-tenant lease, that the organization had entered for the delivery of the service in that specific community at that site. So then this group wanted to take the funding with them and the people and leave all the liabilities behind. And there was a dispute that arose around that, in part because the people who were trying to leave didn't understand what their obligations were. So they filed a complaint with the Attorney General's office. The Attorney General's office contacted our client. And what we were able to do, having done this a lot and worked in this kind of situation a lot, I was able to explain in great detail what had happened, the scenario. One of the allegations they made was mismanagement of funds and things. I was able to pull reports from the accounting software, pull receipts, pull check stubs, cancel checks, all the rest, and show that all the funds that had been received that were intended for that individual facility had in fact been used on that facility, things like rent and payroll and the photocopy machine and license renewals for the people who were delivering the service, and just on and on. They had clearly been used all in appropriate fashion for that individual site. And ultimately, we did all of this within 45 days, and the Attorney General then completed his investigation, and it sent a letter back to the complainant, and it said, we've investigated, and we have been able to identify that there has been no misuse of funds, and no abuse of authority, no material violations of governing documents or of that state's nonprofit corporation law. As a result, there's nothing more for the Attorney General to do, and we're closing the file. And that really helped then facilitate when they realized, when the party that was trying to leave that individual location realized, oh wait, we actually are not allowed to just take the money, take the chairs and the equipment and the furniture, take the people and the program, and leave everything else behind. Just can't do that way. Then the parties reached an amicable settlement pretty quickly. Like I said, they are entitled and were permitted to leave, but it had to be done in a structured fashion. And so we came up with that structure and it went forward. I think that's one of the beauties of working with a nonprofit attorney, that they're going to really understand the sensitivities of the board dynamics and the board politics and multi-site and the mission of the organization. And they're going to understand, importantly, how to respond to a regulator in a helpful, comprehensive fashion, because if you spend that little extra time at the front end wrapping that package to that regulator to show it's entirely here and it's totally in hand, so do a hard press and get a lot of work done at the front end, winds up being cheaper by a long shot, because then you don't have a 6 or 12-month investigation going back and forth, round and round. Meanwhile, you're trying to avoid litigation with that complainant on this side. It just makes that whole process so much smoother. So that's strategies that we typically recommend, and we sometimes work with the volunteer attorneys. But the reality is that it's good to have an attorney who knows nonprofit law, who can help you and your organization when you find yourself in that situation. There's a third area of risk, and this is actually the biggest area of risk. And this is just the problem with insurance. So, we often hear, our board attorney was just trying to help us, and they tried to give us advice. And then it turns out that advice was really bad. They were genuine in that they were trying to help, but they got it really wrong. And that can be a really big problem. So what then happens is there are two primary types of insurance in these scenarios. The first is what we might call malpractice insurance or attorney malpractice insurance. And that's what an attorney carries on themselves or on their law firm, so that if there is a misstep or a wrong advice given, that the client that they gave wrong advice to could potentially sue the attorney practice, and then get recovery from the attorney for those negligent acts. That is in the insurance space, we call that errors and omissions. E&O, errors and omissions. That's a specific type of insurance policy. E&O. The other type of insurance policy is what we call directors and officers insurance. And that's generally where an insurance company insures the board and the officers and the key employees of a nonprofit for actions that they might take on behalf of that nonprofit. So it protects the people in leadership of the nonprofit. And that's called directors and officers insurance, or D&O. So here's what we think. If we have both policies, we often think this is what happens. We have D&O policy and E&O policy. And so when I have an attorney who's sitting on my board of directors, they're covered by their malpractice insurance. They're covered by their E&O, which is that gray circle. And they're also covered by the D&O insurance, which is the red circle. And so we think that attorney is sitting right smack in the middle, right here in the middle of that Venn diagram. That attorney is here. We got two potential insurance policies, so they can help us all kinds of ways, and we're good, right? And they'll really help us. Well, here's actually what happens. Because when the D&O insurance company finds out that there was actually E&O insurance, and they come to the conclusion that the attorney was acting as an attorney in that moment, then the D&O insurance says, nope, we're not going to pay out, because that was an attorney who gave advice, and that's how they were acting. And they weren't at that time acting as a director or officer, but instead they were acting as an attorney. And then the opposite is also true. The malpractice insurance, or the E&O insurance, says, well, wait a second, they were at that meeting and they were there as a director, and that was the board meeting, and it was in session. So they were being a director. And because of that, we're not going to cover it because they weren't behaving as an attorney during that meeting. So we're not going to provide coverage. So literally, those two insurance companies stand there and point at each other. And what you or I might think is that they both should pay, and that might be true. But the reality is, most of the time, neither will pay, because they'll say the other one should pay. So this happens with some regularity. It's fairly common. We deal with this all the time. In fact, it's so common that many of the larger law firms in the country, many of them, prohibit their attorneys who work at those firms from being on boards of directors of nonprofits and also being attorneys for the nonprofit. They literally prohibit it. They say you can one, but not both. Because of this reality, it's just a risk mitigation tool. So, and you might think, you know what, we would never, Bob or Sally, they're so nice, and they're here to help us, and they care about the turtles, and they care about the disabled kids. They care about, our mission. And they probably do, in fact, care. And so you may be right that you as an organization would never sue them. You're correct. You may very well be correct. But what happens when these situations come up is when things go south. So if the organization closed, it became insolvent and it closed, and so it's in some sort of bankruptcy type of filing. Or maybe there was a really bad accident and the damages exceeds the type, the face value of the claim, right? Or maybe, and so then the creditor brings an underinsured type of claim, and that creates additional exposure because the board didn't make sure it had adequate insurance, and the attorney said the insurance they had was okay. So that kind of situation would implicate the D and the E&O insurance, because that creditor who was harmed badly is trying to go after the organization for more money, the insurance policies for more money. So then what happens is the organization is no longer in control of who sues who when. And the insurance policies, the general liability insurance and the D&O insurance and the E&O insurance all start suing each other, and the nonprofit gets stuck in the middle of this whirlwind of insurance companies chasing each other for money. So you may be absolutely correct that you would never sue Sally and you would never sue Bob because they're great people and they're volunteers and they're attorneys and they're trying to help you. But the reality is your insurance companies may very well, and you might be stuck pursuant to your contract with them with having to facilitate that kind of lawsuit. I've seen it time and again. We've been brought in as standby or backup counsel in several of those cases. There are scenarios, especially when you deal with high-risk populations. If your organization is serving children, you're serving people with disabilities, people who are elderly, especially if they're elderly and infirm in some degree, to some degree. These are, high-risk populations, and let's say there's some sort of, allegation of molestation or something like that. Commonly, there's very low coverage amounts, and those claims are high dollar. They usually caught or settle, if you will, the face value or the value of those claims of a legitimate molestation claim is often between $1 million and $2.5 million. But we see insurance policies who cap the liability payouts at $100,000 or less. So it can definitely create issues there. My point to all this is that you may think you have insurance, but in fact you do not, or you might not. And so it's worth looking at your policy. It's also worth making sure that the attorney you hire to work with you, is adequately protected. So yeah. So, to conclude the insurance piece, it is critically important that when you start to get into major issues, such as the issues that are listed on slide 3, on governance or MIFA or membership rights or officer responsibilities, and especially if conflict starts to develop, it's critically important that either one, the attorney who's on your board, you make it crystal clear in writing when they're operating as a director or officer and when they're operating as an attorney, and that they never operate at exactly the same time. In the alternative, you would want to make sure that you're with an attorney who is not on the board, so that you're making sure you're getting just legal advice from the attorney. Slide 6 here deals with what topics. So this almost is like another checklist, right? This is not to say that all nonprofits should go with attorneys who do nonprofit law all of the time. That's not what we're saying here. What we're saying is that there are a few areas, 4 or 5 of them are listed in the left column here, that should absolutely work with an attorney who does nonprofit law, or you make sure the attorney that you're working with becomes competent, highly competent in these areas. Others are on, again, slide 3. But there are various things that you still can absolutely and want to seriously consider using your volunteer attorney or your attorney on the board. Things like landlord-tenant, real property issues, transfers of things like that. Maybe straightforward vendor disputes, even some HR and employment issues if they don't expressly implicate the nonprofit exceptions. And there are some other topics as well, right? I mean, in terms of the way you mitigate individual risk to certain high risk, risk in when you're high risk populations, because this is more going to be based on state tort law than it is nonprofit law. But when you get into topics along the left, regulatory investigations, membership issues, UBIT, which is the unrelated business income tax, and others, then you really need to think about making sure you work with an attorney who does nothing but nonprofit law, or an attorney who is willing to spend the time to become fully cognizant or competent in those areas. Slide 7. So attorneys who are really good at working with nonprofits have some strengths that become apparent pretty quickly. One of those strengths is going to become that the attorneys understand the multiple types of stakeholders within a nonprofit. So is going to be able to, or going to need to be able to work with a board, work with officers. The organization has members, need to be able to work there. Would also need to know how to interface with donors or message for the nonprofit in terms of navigating donor relationships. So many attorneys just say things like, say nothing to no one ever. And
Nope. Did we lose Zac altogether there?
Looks like we did. I'll try to get him back online.
Okay. Sorry about that, guys. We'll take a pause here real quick. Thank you all for your patience as we get Zac back on the call. David, I see your question in the comments. So just letting you know we did receive that. We'll go ahead and address that at the end.
Zac is just going to try to call back in so that you'll still be able to share the slides, but hopefully he won't have to work with the internet anymore, so this won't happen again.
Okay.
All right. Zac, are you there?
Okay, I hope you can hear me. Can you hear me?
Yeah.
We can.
Awesome. All right, thanks so much for your patience. I have no idea what's going on. My computer sounds like it's blowing up and is very hot, so I have no idea what's happening. This has never happened before. Thank you for your patience. In terms of what should you look for in a nonprofit attorney, right? A nonprofit attorney is also going to be able to give you a fairly firm estimate with clear guardrails and then be able to stick to it. That's not to say that things don't happen, because they do in litigation or negotiation, strategically with opposing parties or counsel when that comes to it. But the reality is an attorney should be able to give you a fairly firm estimate for that specific scope of work and then stick to it. And then on top of it, communicate effectively about any changes. I've already talked previously about an attorney would have deep knowledge of nonprofit inner workings generally, and would then be able to learn about your organization's inner workings fairly quickly, and then advise in a manner that is sensitive to various of those sensitivities. You should also ask when you're doing attorneys for a project if they have experience with similar problems or issues that you're facing, and if they have experience with similar types of nonprofits that you're working on or working with. That's another good area to consider with those kinds of attorneys. And lastly, attorneys who really know a lot about the nonprofit space should be able to talk about nonprofit specific topics with precision. That's not to say that they would know every answer of everything off the top of their heads or know some sort of specific pinpoint citation to the law in terms of what the answer is. But what they should be able to do is talk in depth pretty quickly about nonprofit specific topics. And so these are, ways to test an attorney who you're interviewing to see if they have adequate knowledge for the situation. Next slide, please. So then ultimately, the issue is attorneys and perhaps your organization may not know what it doesn't know. And the reality is working with a nonprofit attorney who does know about these areas is going to be important. They're going to be able to point to issues and identify solutions that would be effective for your organization in ways that you may not have realized you even needed. They'll have familiarity with regulatory investigations and will be able to navigate the insurance coverage issue more seamlessly because that gap in coverage, as I showed on those Venn diagrams, would not exist when you're represented by just an attorney who does nonprofit law. So that is how you basically identify the risks of legal advice from free board attorneys and mitigate those risks. Next slide. Are there any questions?
I believe we do have one in the chat right now, so let me read it out to you, Zac. It's from David. He goes, so are you recommending that if an attorney sits on your board, that you make it clear that they are not acting as an attorney for the organization and seek separate legal counsel?
That is one of the two best ways to approach that situation, yes. You either work with that attorney to make it clear that they don't act as the attorney, or when they pivot in a given situation to acting as an attorney, we make it clear, sort of for the record, if you will, that they are now acting as an attorney. So for example, if a board is dealing with a situation and there's your nonprofit serves children and there's a disgruntled family in some sort of way, and that issue has been elevated to the board level, and that attorney sits on the board and they're at the board meeting, then the attorney would naturally just want to start assessing what the risks are and maybe talking them through with the board. Prior to taking that sort of natural step of, okay, here's the risks and this and that, and here's what I would recommend, everybody should be brought to the same page, whether it's the board chair or the nonprofit CEO or the attorney, but someone should prompt the conversation and says, okay, at this point, and you're now talking as an attorney and only as an attorney. And that's the hat they're putting on. Think of it as wearing two hats and having two hats, and it's simply not possible to wear both. So they would take off the director hat and put on the board member hat, even if they were in the board meeting at that time. And that's the other way to mitigate it. Best and safest course is to make sure that when you get legal advice, you get it from an attorney not on your board. That is the best and safest course, yes.
Okay. Any other questions from any of the attendees? Or David, any type of follow-up to that answer? Okay. Perfect. Well, thank you guys, everybody, for joining today. We'll be sending this out as an email so you guys can download this and watch this on demand and refer back to it in case you ever need to understand what UPMIFA means. I still got to work on that a little bit myself. Yeah. So thank you again for everybody coming on, and appreciate you spending the afternoon with us. Thank you, guys.
Thank you, Trey. again. Have a good one.